Have you ever looked at an employment contract and wondered if it truly means you are signing away all your protections? It is a common concern that touches on the very foundation of your workplace rights. Understanding what you are agreeing to is key to protecting yourself in the professional world. The direct answer is that, generally, an employment contract cannot legally waive fundamental employee rights established by law. While contracts define many aspects of your job, they operate within a framework of existing labor and employment laws. These laws set minimum standards that employers must meet, and a contract cannot fall below these established protections. This principle is rooted in what is known as public policy and statutory rights. Governments create laws, or statutes, to ensure fair treatment and basic protections for all workers. These include rights related to minimum wage, overtime pay, workplace safety, and anti-discrimination. Allowing a contract to waive these core rights would undermine the very purpose of these laws, which are designed to safeguard employees and prevent exploitation. Therefore, any contractual clause attempting to waive such statutory rights is typically considered unenforceable. So, how can you navigate this as an employee? First, always review any employment contract thoroughly before signing. Pay close attention to sections that discuss termination, compensation, benefits, and dispute resolution. If you encounter language that seems to diminish or remove a right you believe you have, consider it a red flag. While a contract might define specific job duties or compensation structures, it cannot eliminate your right to a safe workplace or protection from discrimination. If a contract presents terms that seem too restrictive or unfair, ask questions and seek clarification. It is important to differentiate between rights that are fundamental and non-waivable, and those that are terms of employment that can be negotiated or agreed upon. For example, an employer cannot contractually requiring you to work for less than minimum wage. However, they can include clauses about non-disclosure agreements or specific terms for bonuses, as long as these do not violate existing laws. The key is that certain basic worker protections are guaranteed by law and cannot be signed away, regardless of what a contract might state. These protections serve as a baseline for all employment relationships. Ultimately, being informed about your inherent employee rights is your best defense. Knowing that contracts cannot override basic legal protections empowers you to approach employment agreements with confidence. If you ever have doubts about specific contract terms, seeking advice from an expert in labor law can provide clarity and ensure your rights remain fully protected.